All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
All right, so as usual, we've got a lot going on, and we're going to start out west with our favorite state of California, the Republic of California. Keeping our eye on things out there. There's been, as everybody knows who's been listening to the program, a long-running dispute between Uber and other gig economy companies to treat the California drivers as independent contractors out there. And I think at this point, there's a case that's going to be headed to the California State Supreme Court, despite a recent significant legal win for the gig economy technology companies at the state appellate court. There was a divided ruling handed down Monday that largely backed a voter-approved initiative that a coalition of gig companies had really supported, that really sets the stage for another round of judicial review that will determine the job status of hundreds of thousands of California app-based drivers. The high stakes fight over the measure, which is known as Proposition 22, really has some significant financial implications for gig companies, because classifying drivers who transport passengers and deliver food as employees would put them on the hook, would put the companies on the hook for millions in unpaid wages, taxes, and other benefits for drivers, and really upend the gig economy's entire business model. So why am I talking about this? Again, happening out in California, and we're here mainly in Missouri, Illinois, and Indiana. Well, because remember I told you about two and a half weeks ago, President Biden nominated Julie Su for the Secretary of the Department of Labor. Julie Su previously was the Labor Secretary for the state of California, where she worked closely with unions and other pro-employee groups, and one of the targets was the gig economy workers, the gig economy workers, and she was really going after the gig economy workers out there. In this court decision upholding the ban that was Proposition 22, which allows the gig economy companies to continue classifying their workers as gig employees, as independent contractors. I think that you're going to see that fight giving some guidance as to what may be happening on a national level. So as always, we keep our eye on what's going out in the Republic of California out there to see what may be impacting us here in the Midwest.
So Bert, in this process, so I get the government's position, they want more taxes, right? I get the union's position and what they're doing. Are we hearing anything at all in any of the information you're running across, because I'm not hearing it, where the gig employee or the gig worker is complaining, unhappy, wants it to be different? I mean, that's kind of why they like what they're doing, is the flexibility and freedom to work as they choose, when they choose.
As with anything else in this country these days, Phil, some like it and some don't. Some would rather have employee benefits and paid overtime. I think it's going to be one of those situations, kind of be careful what you wish for. There are a lot of people who work for gig economy companies that, again, would want those benefits and those protections under law. And a lot of those people happen to be bankrolled by special interest groups who are looking for the right case to take up to the court systems to try to establish that they are employees and not not independent contractors.
Okay. Well, we'll be careful what we say, because we know Monique is listening and always going to correct us. So we're being careful here, Monique, and we're walking the middle line. All right.
Phil, why encourage her? Okay. Yeah, I mean, seriously, just quit. All right.
All right. Moving on, lawyer on
all
the
right.
clock.